Hi, BGG. How are you?
Hi, fine, fine.
Hello, Payal. Hello, Payal.
Hi, Jaspreet, how are you?
Not bad. I just finished my session and headed home.
Yeah, just
I'm
start.
at Andheri. Yeah, I realize.
Fine, file. Let's start in some time immediately. I think it's 12:30, right? Just about to get 12:30. Let's stick to our time.
Give me a minute. Namaste, good afternoon, and welcome to Bloom. My name is Payal Irani, and I'm CEO of Bloom. Today, we have a very dynamic personality on board, and she has been a Bombay High Court Justice, Judge. She is an arbitrator, and many more, and she has worn many more hats. Let me introduce my co-host, Mr. Abhijit Sanskiri. He is a professional CA and also founder and CFO of Bloom. Over to you, Abhijit, sir.
Good morning, good afternoon, madam. It's a pleasure and privilege to have you here and speaking with us. So, before we start, I just wanted to know, how did you become a judge? So, when you were studying, or when you were in college, or maybe I think post becoming a lawyer, you practiced law and you were also a professor teaching in institution. So, how did you become a judge?
Oh, well, how is my father was a solicitor, he was an attorney,
Oh,
and I thought I
yeah.
must be one up my father. And right from the time I was a
Oh.
kid, I thought that is a great degree. But then I started practice with my father, and then I was alone in my practice. And later I was asked whether I would like to be. And that by that time I had my child, and I wanted to settle down because my lawyer life was kind of very hectic in the sense that we had to go to Delhi and Bombay and things like that. So I thought I'll be in one court, and I liked it so much I would not trade it for anything else in the world.
Thank you. So, I've studied law myself, but though I was a chartered accountant, I'm not practicing law. But how different skill sets do you need to be a judge from that of being a lawyer?
Well, is you should be absolutely honest, which is my best quality, especially in view of the fact that in today the honesty is at such a low ebb that I always put it on top. So integrity first, and then I would say the 5 I's: integrity, impartiality, intelligence, interest, and independence of mind.
Oh, I think great. I think
This is what
I'll
a judge requires. A lawyer may not require all of these.
fine. So the 5 I's you mean to say are absolutely essential to be an judge. So just this is out of again academic interest, because many of us may not know. How does one get selected as a judge? Is there an interview, or is there a minimum level of legal practice, and are there exams, or what is the criteria to be selected as a judge?
See, there are various hierarchies from the Supreme Court to the High Courts in all the states, and there are district courts, and there are lower courts and magistrates courts separately in the cities and all that. So now, so far as the first rung is concerned, the magistracy and
Yeah.
the junior division judge, well, it's a little different in all the states of India. But in Maharashtra, if there is a first class student from a law college, passed out first class, he or she becomes eligible, not entitled, but eligible to apply to be a magistrate or a junior division judge, and then goes higher up in the hierarchy. But if you don't do that, and if you want to practice, then there's minimum 3 years after which you can apply. For the district judges, it's 7 years. For the High Court judges, it is 10 years. Now, this is the eligibility criteria. You become eligible to become. But that doesn't mean everyone is entitled, because there are thousands of lawyers, correct? So then they are chosen. The
Yeah.
judges see from amongst the bar who is really good, who can have all these qualities or whatever that you say. And then now that there are so many thousands of lawyers, you have to kind of make an application for all except the High Court and Supreme Court judges. For the High Court and Supreme Court judges, the collegium in each of the states, the Supreme Court judges would see how they are, and then they would decide in the collegium, and then they would ask, and they would send it to the government, and then the government would, as the government is really doing, do to appoint.
Okay. Just to so, firstly, do you think the world is really
I think he's, yeah, he's back. So you are muted.
is this world really unjust as we perceive it to be?
I don't know what you perceive, but I can tell you what I feel. Yes,
Oh, yeah.
there
So,
is.
yes. So maybe from your perspective, yes.
From my perspective. Yes, of course, there is a lot of, you can say, dishonesty, fraud, cheating, crimes, breaches of contracts, etc. And even in the family life, even you must be knowing in the taxation side against the government.
Yeah.
There are all sorts of cases, number of cases which come up because there is someone who is at someone who is doing something wrong, and then you have to go to court. So it becomes unjust either to the other party or from the government to the citizen and citizen to the government or anything like that. And that is why courts are there to do
So
justice.
courts, so courts would be there to do justice, and absolutely there is respect for the judiciary. There is also a deterrence that people have, that if they do not obey the laws or the regulations of the land, they could be facing trial and they would be punished. The only thing which at a lot of times there could be an issue is the delay in getting justice. So, what would you, as a judge, or maybe now as somebody who's viewing it from a different side, view this in terms of delays in getting justice?
You see, so far as these delays are concerned, which are so endemic now, each one of us is responsible. Each one of the clients of the lawyers, that is the litigants, are responsible. There are some litigants who particularly want to delay because they don't want to pay up or because they don't want a particular order and things like that. There are lawyers who do that, not all, but many. And they encourage this kind of delay. And then it comes to the judges, and the judges have, some say 4 crore cases, some say 5 crore cases. Each judge has got about 3,000 cases on his diary. And therefore, you see, there is that much that a judge can do. And I always say that at one time, the judge can hear only one case. He cannot hear more than one case, or she cannot hear more than one case. So these are only the two parties. And therefore, if the parties want to delay, if the advocates want to delay, the judge gets delayed. And of course, the judges themselves also may delay afterwards in giving judgments. And then there are appeals and revisions where they take up those appeals. And then there is delay. So each one of us is responsible. It is like the environment problem. Each one of us is responsible for the environment that we have today got and the climate change that has happened. And each one can do a little bit, and then it would be a lot.
Again, what always was intriguing me is how do you as judges keep a track of all the cases? Because you would be having a lot of cases to dispose of in a day, and there would be piled up cases. So let's say a hearing for a particular case has happened on a particular date, and there is the next date which is after a month. And when it comes up, it may be the third case or the fourth case on board. And suddenly, how is that skill developed in a judge, that he just recollects what is the past and gets up to date?
Yes, it is not only an art, it is an art and a science to develop that skill. In the sense that there must be some kind of management. You see, as they say, there must be a method in every madness. It's like that. The work is maddening. We know that there are so many matters. The matters do get adjourned because of several reasons. That the litigant has not come, they have not filed affidavits, they want time, the lawyers want time, he is at another place, and all sorts of things. But there are cases which come up and they begin. Now, what I used to do is, I used to keep the cases which have begun before me, giving them priority so that I can dispose them of.
Yes.
So when I adjourn them, I would keep them what I say FOB, first on board.
Yeah.
Okay. Now, if the case is getting ripe, like all the affidavits are filed and everyone is there, then the case will be HOB, that is high on board. So I will take up all the FOB matters first. There may be even 6 matters, FOB, first on board, first on board, first on board. They are the ones which I have taken up and I must finish. Once I do that, I go to the HOB, that is high on board. In the meantime, other matters get ready for arguments.
Fine. Note. But do you have, or do judges have a practice of maybe making notes or summing up what they have done so that it becomes easier for them to pick up the thread when the case comes up for the next hearing?
Yes, of course. Each judge takes down his own notes in his own way or in her own way. But everyone will have notes because we hear the arguments, we have read the papers. When we read the papers, we make notes in the margin. We make notes on separate pieces of paper. We have questions to ask. and then we hear the arguments and we may change our mind, and then we start dictating, reading all the papers, our notes and everything, and then that is the order of the judge.
And the judgment obviously depends on the evidence which is laid in front of the court. So at points of time, you may feel, or there may be a strong, I would say, an intuition or a perception, and maybe I may not be using the right words, that yes, the person who's there is either maybe guilty or innocent, but the evidence which is laid down is not saying so. So you may either have to uh, convict him or acquit him. So how does it feel when at times you may feel that this is not the right decision, which is maybe morally there, but legally on record you have to go through. So what goes in the mindset of a judge when he does that?
See, we go only by evidence and not by feelings. We may
Yes,
feel many
yes,
things, but when we
yes.
sit under our oath, we have to see the evidence, even civil matters, even in criminal matters. So it is for the judge to appreciate the evidence. One thing is the evidence that comes, that the judge records the evidence. The second thing is that the judge appreciates the evidence which is recorded. And there are ways of doing it. You have to interpret it, you have to read it as a whole. You have to see what is latent and what is patent. And even latent evidence is very important at times, because it would show that this is how this particular evidence came about. And then, of course, after appreciating it, we consider the law that is there, because these are courts of law. These are not only courts of morality. So, and the law, as they say, law plus X is justice.
Fine. So the Indian Evidence Act 1872, does it still hold valid, or do you think it's
It
so?
holds absolutely valid, no matter what the government says, no matter what amendments come about, and even if there are amendments, the same sections are reproduced as other sections. Some little changes are made which are cosmetic. So all the old laws have stood the test of time. In fact, all the later laws have been amended, and so many laws have been amended once they are bills itself. So many laws are amended as soon as they are enacted, but the old laws have remained, and evidence law is one such.
So we have got the Code of Civil Procedure and the Criminal Procedure just repealed from 1st July 2024. So do you think that's a reformative step in the right direction?
I don't know how reformative or right direction it would be, only time would tell. At present, I can see that most of the things which were there are already kept. Some of the things have been changed, and many things have been incorporated into just one thing. So I don't know if that would become a hodgepodge or that would become just a one treatise. Only time should tell. But so far, our laws, I must say, law is not an S. The administration of law may be S-like, because of whatever you've said. Somebody wants to delay, somebody wants to defeat, and that kind of thing. And therefore, we should strive there and not just go on changing the laws.
Yeah. And with the advent of technology, has this helped? Because I believe there are in-camera hearings or virtual hearings. So would that speed this up, or?
Yes, up to a point, of course, it will speed up. Now there are e-filings, for example. But I do not see how knowing 5 crore cases by a litigant can solve any problem or expedite anything. Because a man wants to know about his own case. He doesn't care about so many other cases when it comes to court. He wants to see whether his case will come up, whether his case will be decided, or any such thing, So it goes up to that point. This grid and all that is for the lawyers, because you want to see the law, you want to see the judgments and things like that. But I would say that online hearing is a very good thing, because if you even have hybrid hearing, then there can be people who can be from various sectors, and then they need not have the adjournments that they are applying for. They can get on, like you and I have got on just now. So we are very cozy in our own houses today in the afternoon on Sunday, but yet we are talking to one another. So it goes on, and now the program will soon get over. That online hearing is a very good thing that COVID has left us with.
So, would there be a solution that we have more, let's say, online courts for dispensing justice at maybe a particular level of cases, or we increase the number of judges or the number of courts? So could there be any systemic changes which could be done to speed it up? Anything in your opinion which could
I'll
be
tell
done?
you. See, one thing will not speed up much,
Yes.
but
Yes.
many things together will speed up a lot. So if
Yes.
you all have online hearings, then you have everything online, so that even from the trial court to the high court in the appeal, and then to the Supreme Court in appeal, everything can be sent in a matter of 1 minute without any papers. That will speed up a lot. When you have online hearings, means that you see everything is online, and therefore whatever happens, but the judgment comes, and the judgment can go the very next day or that same day to the appeal court. It can go along with all the papers, all the affidavits. That would speed up a lot. Then hearing online would speed up a lot. Of course, having more judges will speed up, but this will be judges who will be able to dispose of, who will be eligible, thinking, etc., etc. Because if you are going to appoint 150 judges also who will not work, nothing will happen. But of course, judges have got so much work to do, each one works. The thing that we have always missed out on is management. If you see the corporate sector, they work on fine management principles. If you go to management colleges, they teach you by way of so many parables also, so many management principles which are applicable to the legal profession and to the judiciary. And I've written in my book about them, I've written articles about them. Once judges learn to manage, which is the only stumbling block, everything would fall in place, because then with these online hearings, more judges and litigants and lawyers having the character to actually go on, and everything will fall in place.
So
But
just
we
one.
miss out only on mismanagement.
So one just thought, which is because we are having conversation, and when you said management and administration, so would you think maybe which should have something which we all other professionals have, a continuing professional education, something on management,
We
so
can
that
have,
maybe they could manage it better.
of course, you can,
So
because management is a science. It's not an art, it's a science.
Yeah.
It has to be learned, it has to be inculcated. Now, there is one degree in one of our Bombay colleges, MBA law. Now, that is a very good thing in the right direction. But how far the lawyers of today and the judges of today can take it up is a moot question. Because the whole kind of, our whole board is not well managed. It may come up in the next generation. But yes, management principles, there are several things like core competence, like specialization, like simplicity. These are all management principles which are applicable to our profession.
So on this management side and on the delays, when you come across, or when judges come across cases where the litigants or their lawyers are frivolously taking dates and extending this, can some action be taken to speed it up? Maybe would this be treated as contempt of court, or contempt of court is a different concept altogether?
Contempt of court will be a different concept, but it can be managed in the sense that we can order costs, we can refuse to give adjournments.
Yeah.
All those things are there. If a judge wants to do it, depends upon the personality of the judge. And it's not that with every judge they do the same thing, with lawyers as well as litigants.
And when you talk about appreciation of evidence, when you said, how much of that appreciation is over a period of time with your experience that becomes on intuition or gut, or is it purely on rational logic and what is the paper on record?
I told you that we don't go by feelings or gut or intuition, because that's not a system. That becomes absolutely ad hoc.
Oh.
It can't be. It could be with the kings of the ancient times that he thought so and therefore he did such and such a thing. We have to work under the laws of our country. The constitution and the laws are the ones that we have to uphold. And to interpret that, we have to see various aspects, the evidences, the intent of the legislation, etc.
So interpretation, when it's by the letter of the law and it's the interpretation of the letter of the law, would there be possible different interpretations for the
Yes.
same?
Yes, there could be. There are perceptions. They say when there are 11 lawyers, there are 12 opinions.
Yeah.
Similarly for judges who have been lawyers. So it can be, and so many aspects have got different perspectives. The only thing is that the truth must come out. That there cannot be any other way. That no, the truth cannot come out. Nobody can say that. We work on the principle of Satyamev Jayate.
So let's say a Mumbai High Court has given a decision on a particular judgment or on a particular footing, and maybe a Madras High Court or some other High Court would have a slightly differing opinion. Then does the Supreme Court decide, or maybe in a third court of law, the judge has his individual discretion in interpreting that based on, as you said, the truth which should prevail, or his appreciation based on the facts and circumstances of the case?
There are decisions of different courts, sometimes similar and sometimes different. Not only slightly different, it may be absolutely different also.
Yes.
The judge who takes up all these matters will be seeing Madras High Court judgment, Kolkata High Court judgment, Bombay High Court judgment, and he will decide whatever he wants to decide. When it goes to the Supreme Court will see all of this and ultimately settle the law.
Again, what's your view on it? A lot of times, a lot of cases get published in the newspapers and there's no context to it as such, and they just give something which is there, and people assume that that's the truth, whereas it's completely a lopsided interpretation at times, because the background, the facts, the circumstances are not given, and people just have a different thinking about what's really applicable. So can something be done to actually stop this, or what do you feel? Because when the social media itself at certain points of time in the case is delivering its own verdict beforehand.
You see, we cannot manage the media. We
Yes.
are in a vibrant democracy. Everyone is entitled to speak what he or she wants to speak. It is an opinion. There may be other opinions. We do read various columns in the paper, and somebody says one thing, another person says another thing. We may make up our own minds. Unless we know all the facts of the case, it is not correct to judge.
Agreed.
That is the
Agreed.
prime principle. Now, today everyone is judging the Kolkata case.
Yes.
There are so many aspects to it. Such a sudden, such a sad, such a bad example. It took place in Delhi, then Bombay, now Calcutta. It goes on that way. But unless you know all the facts, you cannot decide. You cannot think. Therefore, when these things come up in the papers, we ignore them at times. And most of the things are harmless, but some of the things are harmful also. Harmful not only to create opinions which are wrong, but harmful also perhaps to sometimes lead the case the wrong way, which has happened in some cases. You see? Now, the media may kind of, you're asking me about the media, not that I can do anything about them. We need the media, it is the fourth estate. And I would always want the media. But everywhere, there are some drawbacks. There may be more pros and some cons. Now, I'll give you a couple of examples if you want.
Yeah, sure.
And you will realize that it is harmless, but it so happens. When one of my matters, the father took away the child from the estranged mother. And the parties were estranged. The father took away the child. The mother applied and said, I have custody of the child and he has taken the child away. Please give me my child. So the father says, no, I am the legal guardian. And therefore, I cannot kidnap the child. And therefore, I have not taken it. I said, no, you are not the only legal guardian. As soon as you are not there, she becomes the legal guardian because she's the mother of the child. Okay? So the thing was that both are legal guardians. in the absence of the father, the mother becomes the legal guardian. This is what I meant. And I said, you are not the only legal guardian. What came in the papers was, father is not the legal guardian. I got. So I
So
went for
that's
my morning walk,
yeah.
and when I come back, my husband says, "What have you done? You said that the father is not the legal guardian." I said, "What nonsense!" And then I read, and I said, "Oh yeah, I said that you are not the only legal guardian. She is also the one, and therefore you have taken it from lawful custody. Therefore, it would be kidnapping. Give the child back to the mother and apply for custody when you want."
So
So these
is
are the things that happen, because either we say that when an order or a judgment is given, the judge kind of underlines or makes it bold or tells that these are the things which must be printed, which we don't do, because everyone has got the right to print what they want to print, to speak what they want to speak, and this is the difference between the cup and the lip.
so when an important case is going on, which obviously in your distinguished career, you could have had many important cases going on where parallelly there could be reporting which would be going on in the media itself of what can happen. Now, I'm just speaking from a judge's mindset. Do you actually read the newspapers or you just shut off
At least
from
at
what's
that
going on
time,
externally?
we don't. At least at
Yeah.
that time, while the matter
Yeah.
is just going on, we go on, we read only the matter. I can speak for many of the other judges. I think all of them. We don't get carried away by what is mentioned in the media or what is mentioned by one person or anything like that. But
No, so
after the judgment is given, yes, we may feel, oh, now this is the opinion. This is one of the opinions, this is the other opinion. Because you can critique any judgment.
So I'm clear at the seniority and the pedigree of the judge. He will obviously not be swayed by what is stated in the media. But I'm just asking, do you just shut off from what the media is saying? You just don't read the newspapers or the TV channels what they say, or you see them and maybe yes, you get detached from what it is.
Either
While you
way,
are
anybody can. Some judge may do this, some judge may do that. I'm sure no judge gets swayed.
yes, fine. Now, there's one more thing which a lot of people have issues about. One is the misuse of law, and how would you feel when the law is being misused? Maybe people are interpreting it or making use of loopholes in the law for their own advantage, or maybe corroborating with evidences and the likes.
See, there are many laws which are misused and abused. There are all welfare legislations which have been abused. There are even procedural laws which are misused. We see them and we pass orders depending on the misuse. The quicker you pass the order, the better the remedy. Because if a misuser or an abuser will know that he cannot go far, he will not abuse. It is only when the abuser says, kya hone wala hai? That kind of thing, then he abuses. But so many laws are misused, and there are so many times when we see that no, this is not what the law meant, this is not the intent of the law, this is frivolous, and therefore we don't grant those orders.
So especially when the Domestic Violence Act, some laws maybe the men perceive this is slightly in favor of the women, and the women are misusing it. So is that fair? Because one, the law serves a larger good, and maybe a certain percentage which may be misusing it, larger percentage would actually benefit. So in that case, the law is really fair.
See, whenever we talk of abuse, we only talk of domestic violence.
Yeah.
We don't talk of any other laws.
Yes.
But as I told you, many laws are misused.
Yes.
Nobody shouts from the rooftops. Domestic violence law is also
Yes.
misused. And people always shout from the rooftops. That is the only difference. Okay? Now, even a small act like the MPID Act, which you may not even know about, that is the Maharashtra Protection of Investors and Deposits Act. Now,
Yes.
this was a financial kind of a legislation. Even that was misused. For one promissory note of 1 lakh of rupees, somebody wanted to send somebody to jail. And I said, this is not what you have to come in this act for. And I dismissed the whole thing. Okay? Nobody shouted, nobody did anything. But there was abuse. He tried to do something wrong and it was not successful. Now, so far as the DV Act is concerned, you say it is a little in favor of the women. No, it is completely in favor of the women. And it came about, like all other laws, because the situation in the country at that time demanded it. Now, if you go to any of the municipal hospitals and you go to the burn ward, you will see that they are all young married women who have been completely burnt.
Oh,
They die of septicemia. They die of burn injuries. These are the domestic violences, the grossest domestic violences. Nobody shouts for them because they don't have that lobbying power. But under the same law, another woman like me who can cope up with everything, if I abuse the law, then you will know about it because I shout out loud. Okay? So this is what happens. It is not that women are not abusing, but it is not that the law should not be there because there are many, many tenfold women who need that law. And because of that law, they may be able to survive at least. They come to us and to our counselors, to our courts for pre-litigation mediation. And they say that, this is what is happening. I have been beaten up. I can't do anything, or I cannot, my pay is taken away and I cannot do anything. And we tell them that Domestic Violence Act is the act for you. But when it is abused by those who are abusers and the lawyers who want them to abuse. And that has brought a bad name to a very good act. So when it comes to court, we don't grant them relief. But what can we do? What can the judiciary do for people abusing the law? The judiciary comes at the end of the ladder. They are on the
agreed.
top of the ladder. So only when a litigant wants to abuse, the lawyer helps the litigant in abusing, then such a matter would come up. And when it comes up, we don't grant those people any relief. There are so many such matters which are thereafter settled also. These are not compoundable cases. But the prosecution is then quashed. And that is how it is allowed to be settled. Because we know that it was nothing much.
So in there's one point which you raised, very sensitive point about the poorer sections of the society who just can't afford the cost of the litigation and the length of the duration in which justice is delivered to them. So for such people, what exactly should they do, or where should they go for help? Maybe there is some legal aid which I know, but I really don't know whether the awareness of such processes are available to people in the rural areas or maybe from the smaller third tier or fourth tier cities.
In fact, in the rural areas, at times there are Nari Adalats. They are doing very
Yeah.
good work. They are like the panchayat system. Here we have mediations and counseling. They can go to family courts. There is pre-litigation mediation. The thing is, somebody must guide a person who doesn't know. Now, if you don't know which theater to go to, for example, to see a movie, and somebody guides you and says that you go to Churchgate station and then walk up this way and you'll come to that theater, you would go there. Otherwise, you won't be able to see the movie. It's the same thing. It must be that somebody must be there to guide. And women and there are so many NGOs who are working for it. The Women and Children Department is working on it. In every court, we've got mediation centers and counseling centers. In family courts, we have pre-litigation mediation. So things are falling in place, and people are getting that. And again, their correct advice must be given.
But are these alternative legal forums like mediation, conciliation, counseling, or arbitration really working, or have they picked up to that extent which they should?
Well, they have picked up to a very great extent. I don't know what should be there because that depends upon how many litigants want to come to court at a given time. And whether each one can have what we call access to justice. But there are things which are improving, there are things which are being done. We must know how to access it. We must guide them into doing it.
And you've done a lot of work for gender reforms and gender equality. Would you like to share something on that?
Well, I've written a whole book on that, so I can't share the whole book. But
Yeah,
that
but
is on
in a
gender
nutshell, yeah.
equality.
Yeah.
It's called Women, Her Trials and Triumphs. And I've shown how in thousands of such illustrations, gender perceptions come up, which we don't even realize. People think that domestic violence, divorce, rape, and employment are the only things which relate to gender, which is completely wrong. These are not only the four things. In every corner of in every lane, you will find some kind of gender perception. And that must go from the beginning. And therefore, as they say, teach them young, it is forever. So right from the beginning, if we are going to have distinction between our daughters and our sons, sons must get balls and daughters must get dolls and things like that, then this perception sets in.
But is this perception, what you call the gender discrimination, a part prevalent throughout the country, or is it in certain pockets, or is it in certain religion, or in certain education strata, or is it across?
It is universal. I have written in my book that if we go to Antarctica, then there will be gender discrimination in Antarctica also. It is everywhere in all countries, in all stratas, in all religions. I don't know why you should bring religion in this at all, but in all regions, in all communities, everywhere. It depends upon how a mindset is developed.
Yes.
We have had it in Harvard University. We have had it in BBC. And we have had it in our farms.
Fine. Thanks. So you've written an entire book on it, and I would seriously like to have a copy of the book and read it definitely. Yes, and just on a lighter side, what would be the next book you would be writing on?
No, I have not thought of the next book. I've written 2 books, and my first book is coming into the 2nd edition. It has been published now.
Yeah.
So I have updated and that also, and I propose to do that with my 2nd book. Get that into the 2nd edition first. Then I'll write the 3rd book if at all.
Sure. And just another question, not from the legal side. So I'll ask Pai to take over in some time. So as when you were a judge, and maybe there might be cases where they would have been stressful. So how did you manage to maintain your maybe a work-life balance, or just not have that pressure onto you, or is it something which all judges with experience develop that skill, or do you have any hobbies which you practice aside or something of that sort? So on a slightly personal side of the question.
All judges have developed this skill. All judges know how to deal with cases and how to have the work-life balance. They have their family lives. Only thing is, a judge should not become biased because of a particular family setup or your communal setup or anything like that. You should not feel that that is the only right thing to do. You must see what the case is. And you must not be guided by all those things which are prejudicial. That's all. We all have work-life balance, of course. And we are all male judges as well as female judges. We have a lot of family backing and things like that to be able to take the stressful industry.
Fine. So there is a support system, and mental toughness is also one great skill I believe all of us as professionals need to have. So just before our last question, before Payal and maybe the audience can take over, without naming the case, any case which gave you great satisfaction or which was very challenging for you, and which you could just like to narrate that in brief?
Well, I can perhaps narrate one civil and one criminal case to make you understand, but it will take some time. This is the last question.
Yeah, but we have time, so you could take your time. Yeah.
Okay. There was a 5-year girl who was molested outside her hutment. And that case came up before me, and that was before the POCSO Act came into being. It was in about, I think, 2001 or so, when we didn't have this POCSO Act. And I thought that that was a very sensitive thing. That poor girl, she was 10 years old when she deposed before me, when the case came up for hearing. And at that time, my son was also 10 years old. And I was thinking 5 years ago, he didn't go through all this. And it was a case where I had to take the evidence, some part of her evidence, some part of somebody else's evidence, put the pieces together. And of course, I granted 10 years. Now, for that, what I did was that I thought that this kind of a matter, this kind of evidence, I had read up the papers, the girl cannot speak in the court. And she's so tiny. And the lawyers scream and shout that we cannot hear her, we cannot see her, and all. So I decided to have that trial in my chamber. That was the first time I did it, and it was not being done before. Because only this talk about this in-camera trial, which is a very fashionable term, is not right.
Yeah.
In camera trial, that victim girl has got who? The judge, the police, the prosecutor, the defense counsel, the accused. All of these people are the ones that she really fears. She doesn't
Yes.
fear bystanders. And the
Yes.
bystanders are asked to get out, and only those people remain in the court. So she feels all alone against all that entire army of people who are against her, including the judge. So I didn't want to give her that feeling. And my staff was very good. And I told my staff that we will do it in the chamber in the afternoon because she was going to school in the morning time. And I kept it exactly after the recess. I said, call it out and then we will come in. So I went to the court. They called out the matter. I said, please come to my chamber. And I just left. And this was the first time I was doing it, you know. So I told my staff, send the girl in first. Then you send in the prosecutor and the defense counsel. And then keep the accused right behind the girl. And the peon and the police will be at the door. So I went, I took out my band and gown. As soon as she came in, within 2 minutes or so, I only gave her my hand. And I told her, beta, आज last time मुझे सब बता देने का है, हाँ? मैं तेरी story देख लूंगी और सब हो जाएगा. That much I told her. And then both the lawyers came, and I told them that she is sitting right next to you. Please don't shout. She can hear you. And I told the prosecutor that the identification of the accused will be last when her evidence is over. He began the evidence. She didn't know that the accused was right behind her, as I had directed. Luckily, he was quiet. He could have made some noise and made some trouble, but he didn't do that. And both the lawyers, the prosecutor started, she gave her evidence and everything. And then I had to tell her, I said, okay, beta, ye kisne kiya tha? So she says, auntie, wo uncle nahi hai idhar. Which means that she had not seen the accused. And she gave me a whole story, which I took down. You know? So I said, nahi beta, aisa kaise ho sakta hai? Idhar udhar dekho, chalo utho. So she got up. She turned round and she saw the accused right behind her. Behind the accused was the wall. And she turned so ashen. She was white. And I thought, now I've done my best, but she's not going to identify him now. She will say, I don't know, or something like that. Then I can't do anything because there's no evidence against that man. But then I decided that her face is his identification. And I'm going to accept that case because we have to see the demeanor of the witness. And once I was thinking of doing that, she turned back to me and she says, auntie, yehi wo uncle hai. Quiet. So I took down that. And I also took down her demeanor. And I gave my judgment and I sent him to jail for 10 years. And this happened because she was in my chamber and did not know that the accused was behind her. This was a zero budget thing. I did not require all those mirrors and all the curtains and any of those things. Our chambers are fine enough. And in camera, if you see the dictionary meaning in law dictionary, it means in a focused place like a camera. So that is in a chamber, camera chamber. So I felt that at least I did her that justice, and I did it justice. That was
Thank you.
an opinion matter.
Thank you. Thank you. Any other wanted to say another case, or this was the criminal one, civil
And
one?
there was one civil case. I won't talk about many criminal cases. There are many, but there are more
Yeah.
civil cases.
Yeah.
And there was a case of a Hindu widow. And what happened was that her husband met with an accident and died very suddenly. She had a 6-year-old daughter in first standard. She was a housewife and who didn't know anything. He was sort of in a job and he would have his pension and provident fund and all of those things, and he had his other investments, and they were living in a nuclear family, he, she, and the child. Now, as soon as he died, the mother-in-law and the father-in-law of this lady came to the house, and then she was thrown out of the house. She went to her mother's house. The daughter was kept with them, with the grandmother. The daughter didn't know. She was just 6 years old. The mother never came back, and the daughter thought that the mother has left her. And the mother could not perhaps take the daughter because she was in her mother's house. In her mother's house, there would be the brother, there would be the baby, there would be their children, and all of those. Now, this lady, she was the nominee in the Provident Fund of her husband. So she took the Provident Fund. And the pension, of course, she is entitled to half, obviously, as a wife, and the daughter is entitled separately, which she was taking because the daughter was not with her, and the daughter was a minor child. Now, the other party, that is the mother-in-law and the father-in-law, they kept the entire flat. He seems to be, later we found out had some property in the village, wherever, that also was with them. And whatever were his other investments that she never knew about. And when she applied for administration of the estate, they said, no, she has taken away the Provident Fund. Therefore, don't make her the administrator. Now, this Provident Fund, if she has taken, let us say there are 3 lakhs, the mother, she, and the daughter will be entitled to 1 lakh, 1 lakh, and 1 lakh. Correct? And that can always be accounted for. You are a chartered accountant, so you know the addition and subtraction. But what
Yes.
about the entire family? So the case that was brought up before me was that she left the child when the child was an infant. Now, if she had left the child when the child was an infant, then the child was only with the father until the father died. And the father would have required his mother and his father to come and work for the child because he was working. He was in an office. And that case could not be taken up because of this Provident Fund thing. He had nominated her. If she had gone away, he would have changed the nomination. He would have nominated his daughter, he would have nominated his mother, but he didn't do that. And the second thing was that he continued to live in a nuclear family until he died. Now, if she had left away, there would have been no such nuclear family, and the child would have been supported either by him or by the grandmother. So
Yes.
that case was completely wrong based upon this latent evidence. And this is what I meant when I said appreciation of evidence. Evidence
Sure.
is oral evidence and documentary evidence. And both this evidence together must be appreciated. So I granted her the letters of administration. And I said that when she administers the whole estate and gets a third of the estate, which includes the flat also, she will have to give up and account for 2/3 of the Provident Fund which she has got.
Thank you. Thank you for the wonderful stories, and thank you for the entire.
You can read them in my book. These stories
Yes,
are my first
I'll
book.
definitely.
Yes.
Session. And Payal, please take over. I believe there are quite a few people who have raised their hands wanting to ask some questions. So you could take them one by one and maybe any question which you have. So over to Payal.
Yes, Roshan, what an enriching session. Thank you for gracing the Bloom platform. And I'd like to for our audiences who are waiting and listening patiently to you. Any questions you all have, please unmute yourself and ask. Yogesh and Jaspreeta had raised their hands.
Yes, I'm just Preet here. I'm driving, but I still have a question to ask. So, ma'am, you watch these Hindi movies, okay, and you see somebody playing the role of a judge, and then does it happen that sometimes you are very annoyed with the role and how he or she has played her character, or you think it could have been better? Because some of it, I'm sure, is inspired. And which is your favorite movie where it has been reflected nicely?
I do not watch movies. I do
Okay.
not watch Bollywood. I used to watch
Okay.
them when I was a college girl, and I knew
Okay.
that it is not as it was happening in the courts. My
Right.
favorite movie, so far as this is concerned, is Witness for the Prosecution, but that
Right.
also was very dramatic,
Right.
and a lot of different things happen in the courts, and it's best
Okay.
not to really get carried
Okay.
away. Even the court, the movie about the court or something like that, which was supposed to be a very kind of a serious movie, had a
Right.
very great flaw. It was
Right.
completely against our system.
Right, right. And the homicide that happens, in the Western countries, there's a very different system of dealing with it, vis-a-vis India, the trial system. I don't know, I have just seen it in the movies, and hence I'm asking you, but does that work better?
Yes,
Because
it
it
would be
really,
much better because there, you see, and when I say this, I talk about, say, countries like England and America, which I know about. In England, which I have learned about, and I have gone to courts and I've sat on the bench. So I would be able to talk about those countries, not about all countries. And the recording of the evidence today with the technology that you don't have to go on reproducing and all goes a very long way. The judge only interrupts when there is an objection, and he upholds
oh,
it or he sustains it or he doesn't, and she doesn't. But otherwise, it flows very smoothly, and then it is recorded, and therefore it can be read. The transcript can be made, so it goes very, very well. And
okay.
I remember a case of a rape which I had heard in the British courts, and it took 35 minutes for the entire final arguments. And
Oh,
the prosecutor and the defense counsel, she had a notepad, and when she was arguing, she used to only take her pages up and down, frack, 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 like that. And not 1 minute was wasted in between. And the case got over.
oh, very nice,
Those
very
things
nice.
happen
Thank
there.
you.
I wish they happen in my country also.
Thank you. Thank you.
But the point, I think, madam, what I bring is a lot of people still get influenced in India because of their awareness of law is very poor and how justice is different. So the manner in which the courtrooms are shown or how the trial is conducted is actually quite wrong. So for somebody who's seen it gives a very incorrect impression. So that's something which maybe would need correction, I think, somewhere
No, I,
through.
I, I told you one thing is not to watch. The second
Yeah.
thing is to watch and to say that yes, this is wrong, and therefore it doesn't matter to us. That is so far as we judges are concerned. But otherwise, you answer her question that
Yes.
yes, it
So
is
so
really very wrongly done, and therefore it sends wrong messages. But so far as it is not harmful, you can watch those movies and forget about them.
so the first I think when I was a young college student and the first time when I went into the court, I saw only one witness box, whereas in the movies they always showed two. So I was always wondering why why is it so? So a lot of such things which are there. I think yes, fine. So
And that
Pile,
is not the least.
yeah,
Ratika,
That is the least bothersome thing, whether you have one or two witness boxes. The thing is,
yeah,
who steps into the witness box, how is he cross examined, how does he answer? Those are important things, and those are
agreed,
recorded. Then we have to
agreed,
appreciate that evidence.
yes.
agreed. Yeah, thank you, ma'am. Yeah.
Ratika, you can unmute yourself and go ahead and ask your question.
Hi, good afternoon, ma'am. It was a very insightful session. It's for the first time that I'm here and, listening to cases and your experiences like that. I had one question. You talked about mindset. So, I want to understand that with this kind of a patriarchal setup that we have in our country, and with, all the recent Kolkata rape case and the Nirbhaya case, with the kind of brutality that people, the extent that they go to. I mean, how do you feel that the next generation should be worked upon, and what is it? What are the steps? Because see, the child is born new, right? He is exposed to this world, and then there's a kind of he's fed with all the conditioning here. So where is it that you feel that this first change should be brought in, I know it's going to take a number of years for something for like this to transform. But what, in your view, should be the first step to bring about a shift in this mindset?
When you are talking about the first step, we are talking about sociology and not law, because law comes much later. And as I said, teach them young, it is forever. If every parent teaches every child to respect a woman, this would not happen. When you're talking about these kind of cases, and when they say beti bachao, beti padhao, beti bachao, I would say beta padhao, beti bachao. That should be our first step, Then
Because
we don't have this kind of rascals in the society.
I totally get it, because in Beti Bachao, you've already put her at a, like a helpless position.
Yes.
So
Yes, you can. You can Beti Bachao by Beti Padhao also. But now you can see that you can Beti Bachao more by Beta Padhao.
Beta Padhao.
Because if the beta is really respectful, right in the beginning, we work together. Children must come together, boys and girls, so they understand and respect one another. That is again another, if not the first, then the second step. And then the society develops that way. And then when outsiders say that we are the rape capital of the world, we shout out, how dare you say that?
Do that. Can we have the name of the book that you've published?
Yes, my first book is Tangible Justice, which shows my case law, like these two cases and many, many other cases. And the second book is Woman, Her Trials and Triumphs, which is on various gender perspectives in law and society.
Mm-hmm. All right. Thank you so much.
They are both as ebooks also, and they're on Amazon.
All right. I'll check on those. Thank you.
We have a question written in the chat from Mr. M.K. Sansgiri. He writes, there are innumerable pending undecided civil and criminal cases. What's the strategy to solve this problem according to you? What's being done so far?
See, as I said, every judge can take up only one case at a time. And each judge would have to expedite. Each lawyer would have to understand that we will not waste our time. Each litigant will have to understand that simply at all you don't have to make those things, because if a litigant gives a kind of a wrong statement, the judge will have to go through all of this to find out which party is speaking the truth and which party is speaking wrong, and that takes time. So that is how each matter gets delayed. And therefore, I said our national character can be seen in this. How each one can contribute to this. You just can't wish away all these areas, because every case has to be heard. And every litigant would say, please hear my case, and I want to take time. So the judge will take up one after another. But even then, with case management, with appointment of more judges, with technology, these are the three main aspects where you can really speed up. Case management is somehow not done. Technology is now coming up very well. And more and more judges are appointed, but there are more and more litigations.
Thank you, Roshan, for sharing. Yogesh, you can go
Yes.
ahead. 1 minute.
Yes. First, thanks a lot to Bloom. Honorable lady, my question to you is, you are always talking in the very first thing about generation of lawyers and generation of judges. If I'm not mistaken, the current Honorable Chief Justice is third generation judge, C.Y. Chandrachud. Yes, he has brought a lot of reforms and all. I appreciate that. But what I would like to ask you is, why don't Supreme Court make an ombudsman type of thing, which should be there, which really speeds up the grievances or the pendencies, like how we are having in RBI or Reserve Bank of India, which me and Abhijit, since we are from finance and lending, we know each and every aspect. What is your perspective related to this? Means do you see a future where we will be having the same, where the pendency is reduced to bare minimum? I don't say zero, but reduced to bare minimum, and then it will be totally a litigation free or arbitration free. Over to you, madam.
Yes, there is decentralization by arbitration, mediation, lok nyayalayas, etc. There are various tiers of courts. There are, I don't know how you talk about generations of judges or any such thing, but there are judges. There are many judges. We require more judges because there is so much more litigation. And as I said, it is the actual, ultimately, the national character which will come up. When the litigant will come only for honest cases, when the lawyers will take up only honest cases, and then the judges will see how these cases have to be disposed of. But as I told you, one person is honest, another person is dishonest, and judges don't know who is honest and who is dishonest. So the judges have to go through all of this rigmarole to find out who is that dishonest person. Unless the national character changes, it cannot change overnight to give you all this kind of lack of arrears or any such thing. But we can help, and that help would be by case management, that help would be by appointing more judges, that help would be by internet and all of these e-things, the e-courts, all of these things have helped and will continue to help.
My
If
second
the
question
litigants help
again.
themselves and get more and more cases, then of course it will all get drowned.
My second question to you, madam, is on your stint in UK. Well, yes, I would say UK is an inspiration because it was already our
No, I'm sorry,
colonial
I
master
cannot
once
hear you.
upon a time. Hello,
I'm
am I
sorry,
audible?
I've not got you.
Hello, am I
Yeah,
audible?
can you repeat, please?
Yes. Now you are talking about your stint in United Kingdom, especially the England and Wales Law Society. Yes, we ourselves are having a company in United Kingdom, so we know about the procedures of company house and vis-a-vis to MCA and ROC. Though we are not a CA or CS firm, we are all a proper lenders firm. Now coming back to this question, madam, what is the relevance of Advocacy Act 1961 in current context? Because I feel a lot of people are making hay, especially foreign law firms and big law firms like, I'm not naming, but top 10 law firms. And it really leaves the small lawyers and mid-sized boutique law firms in a lurch. Why can't the Advocacy Act 1961 be amended for the real benefit of the lawyers also, where you can say they are given a freedom of expression in the very true spirit? I feel that, see, there are many things like you cannot advertise, you cannot do this, you cannot do that. Whereas the England and Wales Law Society, for everyone's info, they don't have any barriers as such. So, what is your opinion? Why can't we modify or make a amendment, or why can't we change that? Over to you, madam.
I don't think my opinion counts because this act has not even come up for any amendment. We follow the British system. The British system says we do not advertise. We do not follow the American system, which says advertise galore, whichever way you want. Okay? Yet now, with all this internet and all of these things, there is quite a lot of advertising. And this lawyer is doing this work, etc. etc. So, so far as the lawyers would do whatever that they are even remotely advertising well for the welfare of their client and the society, is all fine. It is when there is some kind of abuse that we require some kind of amendment of the law. But otherwise, the old British system that we still have, which Britain also does not have as much as we have. You know, in Britain also the lawyers are now advertising, as I understand, but not like the Americans. It's okay. And of course, now we find even in India that there are lawyers who are, you can't say advertising, but their profiles, etc., come up on certain of these things. It depends. It may be useful to some, it may not be useful to others. And I don't know whether that would call for change of the Advocates Act.
Thank you, madam.
Thank
It
you.
was an enlightening, enriching session. we never knew how we went through the last 70 minutes. Payal, are there any questions, or you can do a wrap up? I think great insights. I think I just loved the two takeaways. One is the 5 eyes which a judge should have. I think that's good for every professional, I believe. And then the national character, what she said, I firmly agree. On appreciation of evidence. I think there were the three great takeaways. And I would love to, Payal, let's meet and have a copy of her book and read it. And we should have her again on some session again, speaking for us.
Copy of which book?
The
Books.
book which you have written, I think.
I've written two
both.
books.
We will have both.
Okay.
Yeah, we would love to read both your books. Yeah.
Okay, you can go on Amazon.
Roshan, I have a question, but I'll take
Sure,
and we will
yeah, you can
connect with you. Thank you so much for enriching.
Payal, you can ask your question.
Thank you.
Thank you so much for enriching 209 session, and see you all next week for our 210 session. Thank you so much.
Thank you. Good
Thank
day.
you, madam. It
All
was
the best to everyone.
Great pleasure and privilege for having you for wonderful, insightful session. Thank you. Thanks a lot.
You too.
It's an honor to have you, Roshan. Thank you. Great.
Thank you.
Thank you.
Yes, thank you too.